Okay, so now let's talk about the pen register statute and also the ECPA. And we'll start with the pen register statute. So pen register, as we mentioned a couple of weeks ago, is, or a trap and trace device, is getting routing information. And so the idea is it's routing information, not content information. You know, the kind of traditional pen register, trap and trace, we've got our traditional telephone line, right? We've got the telephone ultimately going into, I'm trying to draw a telephone, right, in the house. And so you would be able to put a device on the line or on the phone itself that would say, here are the numbers dialed out of this phone. And then likewise, you'd be able to put a device that said, here are the numbers dialed into this phone. As this got a bit more sophisticated, the telephone company, you know, as telephones started to go digital, the telephone company had records of all of this, you know, somewhere at the telephone company. Here's our telephone company, you know, and is able to supply this information. So now, of course, we've got cellular telephones. Many of us don't even really have or use landlines anymore. And also, of course, we also have email. But the principle still applies in the pen register trap and trace statute that getting routing information as opposed to content information only has to satisfy the pen register trap and trace statute. And so notice the standard is much lower than probable cause. The information is likely to be obtained is relevant to an ongoing criminal investigation. Right, so relevant, that's much lower than probable cause, a very easy showing. And notice also that you don't have to give notice to the subscriber that this information is being gathered. Now with a search warrant, of course, the search warrant gets executed, it has to be returned, and eventually the subject of the warrant gets notice that a search warrant, of course, if it's getting information like physical information, you get notice because they come to your place and they get the physical information, or getting a physical hard drive, right? But as we saw in the amendments to Federal Rule of Criminal Procedure 41, you know, a tracking device or a NIT or a RAT warrant, eventually the subject is going to get notice of it. So here, the subscriber doesn't even have to get notice, right? And the standard is very low. And the idea is, well, the Fourth Amendment doesn't protect this information. It's, you know, third-party information, but Congress gives some protection for it. And one of the places that gets really interesting and sometimes contested is email headers. So first I have to erase my ink here on the slide. So what does an email header look like, and why is this interesting? Well, let's take this. This is an email that I received and get, you know, every day from the IAPP, the International Association of Privacy Professionals. It's their sort of daily, you know, update email. So I got this email. Now, what if we were wanted to get the routing information on this? If the government wanted to get it, what would that look like? Well, if we go behind and look at the actual code of the email, and by the way, if you're using Gmail, there's a very easy way to do this, and pretty much any email program will let you do this. Right, here's the source of the header of the email. So you've got a bunch of stuff that's considered the header, and then you've got stuff below the header that's the content, right, the subject of the email. So what do we get when we look at this header information? Well, you can see here, it tells me where this email was received from. And what is it giving me? It's giving me a URL, and it's giving me an IP address. And then it's also giving me information about the date and the time that this email was received. Well, what can I do with that IP address? I can look up the IP address, and there are, you know, free, easy services that you can use to look up the IP address. When I look up this particular IP address, you see that actually the place where it's coming from is not the IAPP. It's a company called Marketo, which has a data center apparently in California, right? So it's giving me that information. In if I do another lookup on this, I can get the address of Marketo. So what can I do with this information? Well, now I know that this particular email is coming not from the IAPP itself, but from a different source that is located in California, and I have their address. Now, perhaps I want to serve now a search warrant. Well, now I've got an address where I can serve a search warrant, or perhaps I can want to do some surveillance. Right now I have an address where I can do some surveillance. Marketo, by the way, is a very large and sophisticated email marketing company, right? So they're apparently doing the marketing for the IAPP. They help, put the campaign together, put the look of the email together, and then manage the sending out and the tracking and all of that stuff. So obviously in this context, there's nothing nefarious going on. But if you wanted to track and then find out locations, that's how it's done. So there's a decent amount of information that you get from email headers, and some civil liberties groups have argued that using the pen register trap and trace is really insufficient because you get more information, though challenges of that sort haven't really succeeded, and this kind of information is readily available to the government, and is the kind of thing that a provider. By the way, if you then serve an order, and we'll look at the ECPA in just a moment here, there's other information you can get also short of a warrant. So now we know some information that could be gotten through a search warrant. We know some information that can be gotten through a pen register trap and trace order. What if now the government wants to get information that in fact is being captured in transit? And that can include telephone communications, cellular telephone communications, text messages, emails being captured in transit. Well, this is where the Wiretap Act comes into play, and the current version of the Wiretap Act is in fact included within the Electronic Communications Privacy Act. So the standard for a wiretap is the requirement of a super warrant. And the super warrant means, right, probable cause plus normal investigative procedures have failed or are likely to fail or are too dangerous. So it's more than probable cause. It's a significantly higher showing than probable cause. Now, why is this? Well, it's not a constitutional matter. As we've seen since Olmstead, the Supreme Court has said that when the information leaves your mouth, Olmstead wasn't thinking about keyboards, right? But when it leaves your keyboard and it's in transit, right? It's being carried over wires, phone wires, or it's being carried through the radios of your cellular provider, or it's being carried through the routers and so on of your ISP and of the other entities with whom your ISP interconnects. You've given up control of that information, right? It's in the possession of a third party. So constitutionally, a wiretap would be just fine, but it's because of a matter of statute that Congress then stepped in. And notice here that Congress decided to be actually more privacy protective than even the Fourth Amendment itself would require, probable cause plus, because there is this sense that routing information or static information has a certain kind of privacy, civil liberties interest, but information in transit has an even stronger one. At least that's the sense of Congress. Now, this is a higher showing than a warrant, but the government gets wiretap orders every day. Again, it just requires that the government put on some evidence and show why it's a problem to use a normal warrant. If you think of kind of the classic context of the gangsters, the mobsters in the room planning their next hit job, and can the government simply get a search warrant and go in there and arrest everybody and get them to talk? Probably not, right? And in fact, that might even be dangerous. Can the government have an undercover informant? Maybe. Very dangerous, right? So having a wiretap, that's a classic kind of circumstance when that might be useful, right, and approved. Now, just note there are some important exceptions to the Wiretap Act. The Wiretap Act, by the way, makes wiretapping a crime. not only unlawful for the government to do, but also unlawful for a private party to do, except for a private party if it's a provider that's intercepting communications for its own business purpose. So, your cell provider has to be able to monitor its networks. That's okay, with one party's consent. So, what if I am on a Zoom call with you and I want to record that Zoom call? Is that a wiretap? Well, yeah, except if at least one party to that call consents under federal law, it's okay. So I could surreptitiously record our Zoom call so long as I consent, even if you don't, or our phone call, right? Or our texts in transit. Now, you should note different states have different rules about this. So some states have a requirement that both parties consent. So if we were in a two-party state to record our Zoom call, there'd have to be evidence that we both consented, which is one reason why if you're on a Zoom event that's being recorded, when you log in, it'll say recording in progress, because you're at least presumably consenting if you hear that and still participate. New Jersey's a one-party state, so only one party has to consent. You can secretly record a phone call if you want, so long as you consent in New Jersey, and that's okay under federal law. Other states are different. Other exceptions, if there's a FISA order, interception where the communication is readily accessible to the general public, so a radio transmission that is leaks out to the general public. All right, you can record that, copyright issues aside, right? And then emergency circumstances. So emergency circumstances can be really important, and the emergency circumstances sometimes get invoked as a compliance matter with a private entity like a social media company. And this regularly happens where there's an indication that someone is suicidal, or where there's a child in imminent danger, those kinds of circumstances. So now we've talked about the pen register, trap and trace. We've talked about the wiretap. Let's talk about the ECPA and stored communications. Now this is an interesting statute, and it also, like pen register, trap and trace, and wiretap, is going to be making some distinctions. And some of the distinctions it's going to make is content information versus non-content information. So in general, identity and billing records, transaction logs, are going to be considered non-content information. And the requirements that the government has to meet to obtain that information are going to be lesser than what we consider content information. Here's a kind of bunch of possibilities that the government could use to get this information, and in some cases must use, but we have to break it down a little bit to see when and why. So one thing you have to note about this statute is that it's created in 1986. It is really a pre-internet era statute. It is a pre-cellular statute. It addresses ideas about email, but it's really a pre-modern email statute. So it uses these definitions, and it makes distinctions based on these definitions that are really outdated. And what you kind of have to think of is when this statute's created, you've got a big mainframe computer in a room, and you've got kind of your local network of other terminals that are attached to that computer, and then you might have some communications network that's external. You don't really in 1980s, you just in 1986 and before, you do have the notion of taking local area networks, LANs, and then connecting them more widely, a wide area network, WAN, right? And then connecting groups of wide area networks, which is internetworking, right? The internet. You do have that idea. It exists, but it's mostly kind of some military, some academic, things, it's not widely adopted. So this whole model is really completely changed today. And in fact, it's dramatically changed in the cloud, and we'll talk about that in a bit. Everybody agrees these definitions are out of date, yet amending this statute remains an uphill climb. So it is what it is for now. It's unclear under the statute whether a service can be simultaneously an ECS and an RCS. And there has been some litigation over this. When you see the definitions, you'll see a little bit why, because the requirements can differ whether we're talking about an ECS or an RCS. As a practical matter, as a result of the ambiguity of these definitions in the modern context and some of the litigation that's happened, in some cases the government has actually even taken a very conservative stance in getting the higher level of process that it has to get. Maybe that's good, maybe that's not, but that's kind of a result. All right. So what are we doing? Non-content versus content information. Non-content billing and other customer records, either from an ECS or an RCS, can be required simply by a subpoena without notice to the subscriber. Subpoena is the lowest possible standard. I mean, a subpoena you don't have to even go to a court to get. And I always tell this story to different classes that I teach, or this anecdote, I guess. You know, when I was doing civil litigation a lot, when I was in full-time practice, you know, very early on, you need to get some third-party discovery. You need to compel a third party to show up to a deposition. How do you do that? Well, you issue a subpoena. How do you issue a subpoena? There's a form. You fill out the form. All right, I've got an ongoing, this is in federal court, I've got an ongoing case in this district, here's the docket. I, as a lawyer, can sign that thing and issue it to this third party. And this third party is now compelled to respond, compelled to produce documents, compelled to show up at a deposition, or to file a motion to quash. You know, it's the one place where, as a lawyer, you have really the kind of full power of the U.S. federal government behind you simply by issuing the subpoena. And, you know, likewise, the government can do this in a criminal matter under the ECPA, and it just means, you know, the U.S. Attorney's Office has to issue it. Pretty simple. No notice, right? Court doesn't. And why? Because it's considered not communications information. Now, how does this connect to the pen register trap and trace? Remember when we looked at the email header? Now I can, through the trap and trace, get that IP information, header information. Now I identify, you know, this company in California. All right, now I can serve this order on this company in California and get the billing and other information relating to the sender of this email. And then I get a closer identity, right, of who this person is. All without notice, right? And then I can go a little bit further if I want to. All right. So what about a little bit further? We're talking about content information. So in email terms, right, this would be the information below the header, the actual text of the email. Now, you might say, okay, well, isn't this wiretap information, right? Emails get exchanged. Well, here's a place where the ECPA made some distinctions. And said, well, we're not going to view email information, right? And so here, let's have our email. Here's our email. You're sending it. It's going across all the routers and switches, you know, almost at the speed, or nowadays at the speed of light. And then it arrives at some server. And now that information is on this server. And here's your local computer, right? You're going to download that information off of that server so that you can see the content of the email, right? It is in storage for some period of time. And in the ECPA is not considered in transit for wiretap purposes if you're not actually tapping, which would be almost impossible to do with packet switching, right? So it's not considered wiretap, but if it's in storage for less than 180 days under this order, it's still considered something like in transit, right? Not quite in transit, but closer to in transit. And that requires then not a super warrant, but a warrant. All right, you can serve a warrant on this provider that is storing that information and get that content information. Now, one thing to notice about this, right, in the way we do email now, this is outdated. The way we used to do email back in the early 90s, the AOL days and so on, the provider would actually store the stuff, and then you would have a local client, the software, client email software on your computer, which would actually download all of the files, the email files, onto your local hard drive. It would then be on your local hard drive, and using your email client, you'd be able to peruse those emails, and you would store those locally. And usually the provider, like in AOL, would have a policy that after 30 days or 60 days, right, notice a lower period, it would roll off of their server. So if you wanted to store email, you would have to make an effort to make sure you're regularly downloading and storing locally in some kind of file. We just generally don't do it that way anymore. When you use Gmail or Microsoft Office, right, all of that is essentially perpetually stored in the cloud. And when you're viewing it with your client, you're using a web client, and you're simply viewing what's in the cloud. It's not downloading that file locally to your device unless you choose a specific email to store and save for some reason locally on your device. So it's just another way in which this whole thing is really outdated. But it is what it is, right? So if it is stored, and notice, by the way, this one is only for an ECS, and that's the way the statute looked at ECS and RCS. If it's stored by an ECS for more than 180 days, or if it's held by an RCS, then there are various ways that the government can get the information. You can still use a warrant with probable cause, but you can also serve a subpoena, a simple subpoena, right? Again, no court involvement, with prior notice to the customer. Now, it's unlikely that you're going to want to do that. You probably don't want to give the customer prior notice, because that gives the customer in advance the idea that they're a target and what you're up to and so on, and potentially could destroy the evidence. Or you can get a court order called a 2703D order short of a search warrant. It's still a court order, right? But notice the showing is a lot lower. There are reasonable grounds to believe the contents are relevant and material to an ongoing investigation. Well, higher than a subpoena, you still need a court to look at it, right? Lower than a search warrant. And in that case, you can delay the notice to the customer. So like a warrant, eventually the customer will find out, but the notice can be delayed. Now I said earlier, the differences in these definitions have caused some question about some litigation, right? So notice content information for an ECS less than 180 days needs a warrant with probable cause, and then you have this distinction for an RCS. So what does that mean? And when can you use? So for an RCS, could be information held less than 180 days. So are there cases where the government had gotten 2703D orders for information held less than 180 days, right? Did not get a search warrant, argue that the entity was an RCS. It gets all muddy. As a result, the best practice right now for the government is if it's less than 180 days, you get a warrant. In fact, in many cases, if it's more than 180 days, you still get a warrant, because if you get a warrant, that's the gold standard. But we still have this on the book, so you need to know this is how the statute works. All right, so that is the ECPA routing and content information. We talked a couple classes ago about the crypto wars. I'm not going to revisit that now, but this is where that fits in, right? So we've got these abilities, these statutes that let the government get a pretty wide range of information, sometimes with a super warrant if it's wiretap, but with a warrant at least, or even less than a warrant. Cryptography lets us keep certain information from the government, and the question is, that's all valuable and useful, but how far does that go? And we talked a couple classes ago about the Clipper chip and those sorts of things. So we won't revisit all that now. We mentioned back then CALIA, and what I just want to revisit and note for you, right? CALIA 1994, an early internet era, early cellular era statute. CALIA applies to telecommunications carriers, and this is significant because in the Telecommunications Act of 1996, broadband internet were classified not as telecommunications carriers but as information services. So for a bunch of regulatory reasons that was done, but it also means that broadband internet is not subject to CALIA. So telecommunications companies, yes, cell phone companies, subject to CALIA. What does it mean? It means that they have to, they're not responsible for doing decryption on behalf of the government, but they do have to configure their systems, so that the government can do wiretap orders, execute wiretap orders, execute pen, register, and trap and trace orders, and also that if the provider is supplying encryption technology to the customer, then the provider does have an obligation to be able to supply the information pursuant to proper process to the government in plain text form, right, in a decrypted form. All right, well, why? We talked about the Apple iPhone issue a couple classes ago. Why didn't CALIA apply? Apple's not a telecommunications carrier. So we have, debates about whether or not CALIA should be updated to be expanded in that way, or whether that in fact would be bad policy. The last thing we want to touch on for this week is the Cloud Act in 2018. So you need to understand just a little bit of what the cloud is and how it works. And here's our sort of old model of the local area network. You have a local server. This server has the data, the applications, the services running on that server, and whatever devices are on that network, right, are gathering from that server. Now, this might be connected to a wider area network and might in fact be connected to the internet. But nevertheless, the data, the processing, the services are on local servers. In the cloud model, we don't really do it that way, right? We have users who are connecting to the internet, and then in the cloud, right, out there on the internet, are different servers and server farms, really. And those servers and server farms are storing data, but also are providing, increasingly providing services, and increasingly providing the applications, right, that are running. So again, if you take something like Gmail, we have our mail application that is allowing the exchange of email, and we have the emails themselves being stored in the cloud. So we have service, software, and data in the cloud, and we're not relying so much on local servers and local networks anymore. In fact, if we think about how Google actually does this, it's not that your Gmail, is on one server somewhere in the cloud. What Google actually does is slicing, it's breaking up even individual emails, the data that is there, and is putting those data slices in multiple different sites in its cloud throughout the world, really, based on the way that Google's algorithms are showing that it would be most efficient. Now, this raises a problem when we're talking about the ECPA and getting both subscriber information, but really getting content information, because the content could be all over the place. It could be all over the world. And there was a case involving Microsoft that had been litigated and was before the Supreme Court. So you had there an ECPA order being served on Microsoft in California for content information of a subscriber, and Microsoft said, well, that subscriber is actually located in Ireland, and the way we do things in the cloud, most of their content is probably going to be on servers in Ireland because we do things with a geographical proximity. So government, if you want this information, you have to go to court in Ireland. You can't serve an order on us, Microsoft, here in the US. And the US government said, well, that doesn't make sense, Microsoft. You push a button, right? And you've got all that information, so you can draw it out of your cloud. So we are asking you, Microsoft, to push the button in California and to give us that information. So the question was, does the ECPA have extraterritorial effect, or is this even an extraterritoriality question? Or right, from Microsoft's position, does it not, and does the government have to go to Ireland? Now the government could and does go to foreign countries, especially friendly ones like Ireland, and domesticate an order under the Hague Convention or have local process. But it's just much clunkier, and as you can imagine, in countries that are not like Ireland, that are not as friendly, it's much more difficult. So as that case was pending, Congress passed the Cloud Act, which made clear that under the ECPA, an entity in the U.S. subject to U.S. jurisdiction that is capable of retrieving that information from the cloud, right, regardless of whether that information itself is located within or outside the United States, must comply. So it says then that to the extent when the data is out in the cloud outside of the United States, to the extent that requires a reading of extraterritoriality, that the Stored Communications Act in fact has that extraterritorial effect. This was controversial when it was passed with many civil liberties groups. It remains controversial, and there are other aspects of the way this works that are controversial. We won't get into that in depth, but I want you to know how this works, and for compliance purposes now under the law, an entity like Microsoft or Google has to be able to comply with these requests.